Welcome once again to Lehto's Law. Here's Steve Lehto.
Here's another one of those stories that was sent to me by everybody, but this is a follow-up and basically the ending chapter of a story I've done previously. And so it's good to see this ending. I think most people will agree with this, at least that it came out in the right direction. Boss who paid workers final salary in oily pennies ordered to give ex-staffers more than $39,000. So this story version is from people.com. Daniel Levine wrote this, but a lot of people sent it to me. A Georgia repair shop owner retaliated against a former employee by paying him close to $1,000 in oil-covered pennies that were dumped in his driveway along with a pay stub. That was the story. So the owner of the auto repair shop, which is in Peachtree City, Georgia, may regret his decision now to pay that final paycheck in oily pennies. It turns out that the owner and his company were ordered to pay the man who got the pennies and 8 other employees more than $39,000. And that's in a consent judgment from the Northern District of Georgia on June 13th, which included $19,000 in back wages and $19,000 in liquidated damages. And the liquid's not the oil on the pennies. So it turns out that there were other employees who said they'd been mistreated as well. 8 others. And you'll notice this is a consent judgment, which means that the parties sat down and instead of litigating the matter and letting a court decide, they said, okay, we'll agree to resolve these claims this way, and we'll put it in the form of a judgment that we both agree to. And they present that to the court and say, if the court finds this acceptable, we agree to have this judgment entered thus. And so the judgment says that the owner of the company will pay $19,967 in back wages, as well as the $19,697 in liquidated damages. Those numbers are slightly off because 2 of the numbers are switched. That could be a typo. But it's approximately $20,000 in damages and $20,000 in back pay. Meanwhile, at the same time, the man and his company were ordered to remove all photographs and references regarding the former worker from its website and social media pages and ensure that the consent judgment is posted in a conspicuous place at the repair shop. The company also has to post a division fact sheet, and that's from the Labor Division, on the Fair Labor Standards Act prohibition of retaliation in the shop. So an employer is not supposed to retaliate against employees. The Department of Labor filed a complaint against the man and his company back in December of 21 after investigators found that he and his company had violated the retaliation as well as the overtime and record-keeping parts of the Fair Labor Standards Act. And I've heard so many stories of people who told me I worked at a place and I worked for 8.5 hours every day and I got paid for 8. And a lot of places just start chipping away, nickel and diming you here to see if you'll do anything about it. And what's the average worker who really needs their job going to do about some little violation at some small business where they're working as is and they can get fired for no reason? So the guy who got the pennies dumped in his driveway had contacted the department after the owner of the company allegedly failed to pay him his final wages. And so after that happened, the owner of the company then delivered the 91,500 oil-covered pennies onto the man's driveway along with a pay stub. And so it would appear that one was done in response to the other. And if that's the case, that would be what we call retaliation. Now, the pile of pennies was so large it blocked the man's driveway, and the oil stained the driveway and took almost 7 hours for the man to clean up. And to make matters worse, the owner of the company is said to have published defamatory statements about the ex-worker on his company's website. So in April of 21, the man's girlfriend told People magazine they were initially super ticked. They were ticked, super ticked, about the pile of pennies left in the drive, but this changed when it came to cleaning them up. After the first shovelful, all we could do was laugh because this poor, miserable man took so much time to be vindictive and cruel. We absolutely refused to let him ruin a single moment of ours. So to get all of these pennies, the guy had to do a bunch of work. Presumably he did not have 91,000 pennies just laying around. Probably had to go to the bank or maybe even several banks. So the guy's putting effort into this. But she is right. This is the girlfriend who says, you know something? Think about it. That guy is that upset and he's trying to make us upset. Just move on. Just move on. So they didn't let that bum them out. But speaking after this all went down, the U.S. Department of Labor Regional Solicitor Tremel Howard said in a statement, the court has sent a clear message to employers who subject employees to unfair wage practices and outright intimidation and retaliation. By law, worker engagement with the U.S. Department of Labor is a protected activity, and workers should not fear harassment or intimidation in the workplace. And so there is a Department of Labor. And if you contact them and your employer is allowed to retaliate against you for doing that, then people would never contact the department. So employers who mistakenly believe they can willfully violate labor laws at the expense of employees and competitors must understand that we will do everything within our rights to bring them to justice. Workers are entitled to obtain the wages they earned without fear of harassment or intimidation. The Wage and Hour Division will use all tools available to ensure workers' rights are protected and that employers do not retaliate against them when they assert those rights. This case should serve as notice to employers that retaliation will not be tolerated. And that is the Wage and Hour Regional Administrator. And so the strange thing about this story is you don't often hear about the department stepping in on behalf of individual workers or even just small groups of workers like this. I think this is 8 or 9 workers in total who are involved in this story, one of whom got the 91,000 pennies dumped in his driveway. But they are out there. And I assure you that if you were to walk into the office today and say, let's just see, what are you guys working on? They'd say, well, we've got many more cases like this that just don't hit the news. Not necessarily somebody dumping a wheelbarrow full of pennies into somebody's driveway, but somebody who's filed a complaint about unfair working conditions or something, or complaints about wages and so on, and that they then say, oh, and after I did that, I was retaliated against. And so I'm sure that they probably are overworked and understaffed and all of that, but it's just that you don't often hear about them popping up in the news. But the consent judgment is the important part here, because I saw several different versions of this story. And by the way, I've mentioned before, if a story like this pops up, and I got it sent to me by so many people, thank you very much, by the way, that I will go read different versions of it to make sure, because once in a while, one outlet will leave something out or one outlet will include something, and so I'm looking around to make sure I got everything. And the part that I thought was interesting that I did see was not in some versions of the story I saw was that this is a consent judgment. Because if this had been an actual just legal case where they went to court and a judge ordered this guy to pay the money as a result of this, let's suppose it's the exact same result except it's a judgment from a court as opposed to a consent judgment brought to the court and entered with the court, then obviously the guy could appeal it, right? I mean, you go to court, you lose, you file an appeal. And so if somebody had instead taken this to, in essence, trial and lost, this could be tied up with appeals for years. But instead, because it's a consent judgment, there ain't nothing to appeal. Because, if the judge and the court enter a consent judgment that you agreed to, not only will they ask you to probably sign the document or have your attorney sign it on your behalf, but when it's entered with the court will probably ask you, are you aware that this is a consent judgment? And you signed it and your attorney signed it on your behalf, right? You understand what this means. And you're signing this freely, willingly, and all that stuff, right? And so they'll probably go through that whole litany on the record to make sure that this person can't later come back and say, I didn't know what that was. A consent what now? Well, it says consent judgment right here, and you signed it, But a consent judgment means that this should be the end. The end. So it's a fascinating story from beginning to end. I remember when it first happened, and people were actually arguing, saying, well, if the guy's paying you, and he's paying you what he owes you, then you really can't complain. I mean, if he paid you in nickels, how would he paid you in single dollar bills? But the real problem here is that he paid it in oil-covered pennies. So he was doing that as the final exclamation mark on the statement. And that removes that argument. He paid you in a denomination that you didn't like. That's not the argument. No, it's that it was covered in oil and dumped on the ground in the man's driveway. So, crazy story, but it's ended. People.com ran that version of Daniel S. Levine wrote it, and literally hundreds of people sending me thanks a lot. Boss who paid workers final salary in oily pennies ordered to give ex-staffers more than $39,000, and half of that is liquidated damages in a consent judgment. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. There is no such thing as fun for the whole family.